Hello there. Thanks for joining me. I am Dr. Jen, and this is My Life as a Landlord. I'm so pleased you've joined me for today's show where we're exploring location-specific tenancy guidelines for California. In all of my location-specific episodes, I've included hyperlinks to all of the resources that I cite in the episodes today, and actually probably a lot more in California's. There's a bunch in there that I don't talk about in the episode, so be sure to check that out in the description. Each of my location-specific podcasts is set up the exact same way, answering the same four questions. What are the basics of tenancy law? And in this case, the California Tenant Protection Act. What are the nuances of this location? What's different? What stands out? Some of guidance about abandoned items left behind by a tenant in California. And then finally, where do you get help in your local area in California? Now, I must tell you that there are more documents and more resources than what I am giving you here. This is not everything. This will just get you started and give you some guidance. There may be other things in your city, county, state, province, parish, whatever, things like registering your rental, or maybe you need to be licensed as a landlord. You won't know unless you dig more than what I'm going to tell you here. This episode is not all inclusive. You must research further in your specific area of your rental, but today's episode will at least get you started. I will put in a plug today for today's sponsor, Aloha Capital Investments, LLC. If you want to know more about real estate investing, check out alohajv.com. That's alohajulietVictor.com. Okay, let's get into it. Let me screen share and we'll talk about the basics of the California Tenant Protection Act. The latest one was in 2019 for California. Okay, give me a second here. Let me click on. If you are watching on YouTube at My Life as a Landlord, you will be able to see your screen. And because any tenancy law, no matter where you are, a tenancy law is a law, right? And so there is quite a bit of legalese. There's sections, there's all kinds of things. This is very legal. So this is actually the California Apartment Association's link on the California Tenant Protection Act, just at least to the 2019 aspect of it. So there's a lot of links in here. It can get very legal really quickly, but there is also the Office of the Attorney General for California Department of Justice, Rob Bonta. He's got a website that I'm also screen sharing here regarding landlord-tenant issues. And so he speaks to, as a tenant and as a landlord, where to get help in a couple different places. And there's a bunch of hyperlinks to look at the latest revisions in tenancy and the California Tenant Protection Act. So make sure you're looking at this. Limit on rent increases, just cause eviction requirements, at fault evictions, and then no fault evictions. Very interesting, this determination, at fault evictions, meaning there is some reason that the landlord is evicting the tenant at fault: non-payment of rent, breach of material term of the lease, nuisance waste, using the unit for unlawful purposes, criminal activity, refusal to allow lawful entry, refusal to execute a new lease containing similar items. No fault eviction, meaning the tenant hasn't done anything wrong. The owner wants to move in, the landlord wants to demolish or substantially remodel the unit, withdrawal of the unit from the rental market completely, or owner complying with a government order or local law that requires the tenant to leave. And so there's several different more in this about protecting. These have all changed, which is good. So 2019, so this is pre-COVID where this changed, but we're going to go through some of these. Tenants with notice of rent increases. Let's talk about this. When raising a tenant's rent, landlords must deliver a tenant formal written notice of the change. It's not enough for a landlord to call, text, or email that they plan on raising the rent. They must give residential tenants sufficient warning, and if the rent increase is 10% or less, landlords must provide 30 days notice before the increase can take effect. And if it's more than 10%, which you have to really look at, because you're going to see here as we go through this that more than 10% is not the norm. But if that does happen, you must provide 90 days before it can take effect. Lockouts, it is illegal to try evict a tenant by locking them out or shutting off their utilities. You cannot do that. Those are big no-nos as landlords. Security deposits, which some landlords can call a pet deposit, move-in fee, cleaning fee, damage deposit, or other term. It's a money that a landlord can hold during the tenancy for damage or to recover the unit. For most residential rental properties, landlords may only charge a security deposit of up to 1 month's rent and may only use security deposits for unpaid rent, repair, damage. Yeah. So within 21 days of the tenant moving out, the landlord must return the security deposit except for amounts detected for lawful purposes to recover the unit and provide an itemized statement. Notice they did not say you had to, that the landlord had to repair or provide receipts or invoices. But you do have to provide an itemized list. Price gouging. This is the only place that I've seen price gouging specifically defined. Price gouging protections, including protections under city or county price gouging ordinance as a result of local emergency proclamations, may apply to rental housing, effectively limit rent increases. Now, before we go on here, I'm recording this in March of 2025. The fires in Los Angeles happened not that long ago. So the fact that this has been in the California Tenant Protection Act for a long time, more than just a few months, is kind of unnerving, because you've got this and price gouging. I'm sure price gouging is happening. I'm sure it's already happened, because you've got houses that thousands and thousands of houses that have been burned up and not enough people not enough places for people to live. So very interesting that they specifically call out price gouging, but I'm not sure how the economy and supply and demand changing that is going to affect this, because if it's not gouging, it's just supply and demand. How does that play into it? Don't know. All right, we're going to keep going. Retaliation. Landlords may not retaliate against tenants for exercising their rights. And when we talk about landlord retaliation, we talk about rent increases or reduction of services, trying to evict someone. And it always comes down to the timeline of if a tenant or if a landlord is going to try to evict someone, at what point is it deemed not retaliatory? I don't know that, and it doesn't have a timeline in this here, so I'm not really sure about it. They just state what a retaliation is. They don't actually give you the timeline. Reasonable accommodations is also listed here. This is typically with tenants with disabilities to help use full use and get a full enjoyment out of their unit. Discrimination, that's a no-no as well. Getting legal help, you can either contact lawhelpca.org. That is to find the local legal aid office near where you live, or you can hire a certified lawyer by contacting California State Bar. There's also self-help resources for tenants facing evictions. If you're not a tenant, I don't know if they're going to help landlords in this. I don't know how that works. But there are Know Your Right guides for tenants. And then I think there is a couple more for landlords as well. Yeah, quick reference guide for landlords or property managers. In fact, I think I've already pulled this up, but I'm going to click on it anyway, just so we can see. Yeah, there's a bunch of, so just so you're aware, they have these, California Department of Justice has all these consumer alert, they look like slicks, they look like brochures. And so they talk about this, the Tenant Protection Act, they're talking about effective date, so effective of January 1, 2020. What is the act? Who must comply with it? How much can rent increase? We'll talk more about this here in just a minute as we get into rent increases, because it depends on where you are. And then there's like a multiple on, so it completely depends on all of those things. And then depending on what types of evictions are allowed under the the Tenant Protection Act. Let's see. So this is still in the slick. It didn't explain the rent increase, but I'm going to go ahead and click on this. I'm going to open in a new tab. I'm going to click on this because there is a bit of a matrix on rent increases, on how they do rent increases in California. And it's kind of interesting how it all works. But just to give you the general, and then we'll get into what the specifics are based on what county. Rent may not be increased more than 5% plus the change in cost of living pursuant to the consumer price index, or 10% total, whichever is lower over the course of any 12-month period. So here's this slick, and this is Rob Bonta, Rob Bonta. Where is... Okay, foreclosure. So this is resources for homeowners. This didn't click into... Frequently asked questions. How much can my landlord raise my rent? Well, there is a... Bear with me here because there is a... Oh, here it is. Okay. So this is California Department of Real Estate. This is the housing is key, and I know it's in here. So this is the sort of the guide that takes the legalese aspect out of this. Okay, where are we here? Oh, that's the very end of it, because I went through it. Okay, California Tenants. This is a guide to residential tenants and landlords' rights and responsibilities, 2025 edition. So this is going to go through all this. Now, we're not going to go through this page by page. I'm just going to gloss over the majority of it, but look at the table of contents. There's quite a bit of information in here, and we're talking about what's not in this. Things like credit checks, application screening fees. Most of the time you are allowed a nominal fee that will cover the basics of pulling like a criminal history check or a credit check or background check, something like that. Landlord's disclosure, lead-based paint, bed bugs. You know, we're talking about infestation here, methamphetamines, military, death in the rental unit. That's something that's huge. Megan's Law. That's very, very unique to California, is Megan's Law about sex offenders. We'll talk about that here in a minute. Paying the rent, security deposits, partial rent payments, rent increases, short-term rentals, dealing with problems, repairs and habitability. All this sounds pretty normal, pretty standard in this, but let me go through some of the basics of this. There's oh yeah, here's a good one. Here's a couple different ones. So lock changes. Certain landlords will be required to change the locks of a tenant's unit at the tenant's written request at the landlord's expense. Basically, if they're a victim of domestic violence. Interesting. So the landlord's got to help them. And it looks like here's another one under parking. Tenants will be allowed to refuse to pay for parking in newer qualifying residential properties. It looks like if there are brand new buildings that automatically come with parking, that you have to pay for parking. And let's say a tenant doesn't want to pay for parking. Maybe they don't drive, or maybe they don't need to pay for parking. Maybe they don't even have a car. Then they can opt out of that, which is new, apparently, according to this change. And landlords, termination of tenancy. Landlords pursuing no fault evictions for purposes of occupying the property for themselves or relatives face heightened standards of intent and occupancy of evicted properties. Beginning January 1, 2025, a landlord who is a natural person and is a beneficial owner of an LLC or partnership may utilize the landlord move-in no fault eviction process if they have at least 25% ownership interest in the property. Interesting how this all works. So you can move in even if a corporation, an LLC, owns the property. So let's go through this. It's quite long. There's 155 pages to this. I'm not going through this whole thing, but the basics of it, it defines who a tenant is. It defines who a landlord is, talks a little bit about some special situations, looking for a rental unit, how to look for a rental unit. I'm just scrolling down what a rental application should have. Oh, this is different. Criminal history. So landlords are not allowed to, let's see. Generally, a housing provider may check criminal history of an applicant, although there are some types of criminal history information that providers may not seek or consider. Arrests that did not lead to a conviction, participation in a pre-trial or post-trial diversion program of conviction that has been sealed by the court, or any conviction that came from the juvenile justice system. Landlords are prohibited from having blanket bans on all applicants with criminal histories. Landlords cannot be compelled by their local governance to perform criminal background checks or penalized for failing to do so. Instead, landlords must look at the individual circumstances involving conviction to decide whether it's directly related to the applicant's ability to be a good tenant. And there is a hyperlink in here on more information about using criminal history to determine a tenant's qualification criteria. And I have that link in the description of the podcast. So please make sure you're looking at that. That's very unique to California. Let's see, credit report, domestic violence. We talked a little bit about credit checking, tenant screening services, application screening fee. You can charge an application fee, but basically it's just a recoup of the actual costs of the reports that you're going to pay for. The landlord may charge you an application screening fee to cover the cost of obtaining information about you, such as checking personal references, obtaining a credit report about you. Yes. And actually now there's 5 items. Beginning January 1, 2025, a landlord can only charge an application screening fee if the landlord does all of the above. Yeah, I'm not going to read these. There's a lot. Basically, you have to really try. As a landlord, I don't typically charge a screening fee. And honestly, what I do is I will ask the tenant for a copy of their credit report and credit score within the last 30 days and let them come to me with it instead of trying to pull one so that I don't have to pay for it anyway. So yeah. Holding deposit. Holding deposit is something some places have, and what it is, it's a deposit that the potential tenant will provide that basically will just hold their place in line, that is then either refunded or applied to either the first month's rent or the security deposit, should they be chosen. So unlawful discrimination, you're not allowed to have unlawful discrimination. And in California, specifically in California, protected groups or classes include race, color, ancestry, national origin, citizenship, immigration status, primary language, religion, disability, either mental or physical, sex, gender, sexual orientation, gender identity, gender expression, genetic information, marital status, familial status, including families with children under 18 or people who are pregnant, source of income, including the use of house vouchers, military or veteran status, or age. Discrimination based on specific personal characteristics are also prohibited. Yeah, that's more inclusive than federal, I'd say, if I was to put them front to back or to compare them across. It seems very similar, and there might be 1 or 2 extra in there for California, but just don't do it. Just, it's what you would do for one, you would do for all. Very simple. Okay. I am looking for here. Oh, so this is, if you're looking for a roommate, then this is something that makes sense. That if you're an owner of an owner-occupied single-family home and you rent out a single room, then you are able to choose basically your roommate, and you want to make sure that you are changing, you're screening them based on compatibility with yourself. And so you're not subject to the California Fair Employment or Housing Act or Federal Fair Housing Act in that situation. So resolving housing discrimination problems, that talks a lot about fair housing organizations, civil rights department, HUD, legal aid, private attorneys. Okay, so it talks about rent, periodic tenancies, shared utility meters. What should be in the lease, alterations to accommodate a tenant with a disability. Yeah, landlord's disclosures. This is where it gets into the lead-based paint, periodic pest control treatments, bed bugs, asbestos, carcinogenic, methamphetamines, demolition. Oh, this is interesting. If there is a death in the rental unit within the last 3 years. So let me read this. California law requires a landlord to disclose a prospective tenant, a death, and the manner of such death that occurred at the rental unit within the last 3 years. The landlord is not required to disclose that an occupant of the rental unit was living with HIV or died from AIDS-related complications. The law does not protect an owner, however, from liability for making any intentional misrepresentations in response to a direct inquiry from a prospective tenant who asked about a death at a rental unit. So you want to make sure that if there was a death in the unit at all, you must disclose that within the last 3 years. The other interesting one, Megan's Law, a landlord must include the following language in each and every rental agreement in California. Notice, pursuant to section 290.46 of the Penal Code, information about specified registered sex offenders is made available to the public via a website maintained by the Department of Justice at meganslaw.ca.gov. Depending on an offender's criminal history, this information will include either the address at which the offender resides or the community of the residence and zip code in which he or she resides. That's very interesting. I don't know if you've ever looked at sex offenders near your rentals. It's a little bit frightening. And the fact that California is putting Megan's Law in the leases is kind of sad, but it is what it is. That's what they've done. Okay, this next bit is about security deposits. Again, it talks about the application screening fee, security deposit scenarios, military personnel, inventory checklist. This is what I call a condition inspection, and actually California has a really good one. So it talks about, at move in, what's the condition, and then at move out, what's the condition. Also, there's talk about renter's insurance, including negligence, limits to increase, local rents, including local rent stabilization programs. Let's see. Living in the rental unit. I haven't seen the matrix yet. I know I've captured it, but haven't seen it yet. We're coming to that. Okay. So if you're paying rent by check, money order, electronic funds, or cash, then there is a dishonored check, an NSF fee. And so then you can charge a service fee on top of that, because there was a bounce check. Receipts for rent payments. Everybody must have a receipt of some kind, and including if your tenants pay by cash. Okay. So NSF fee, let's see, local rent control. Oh, that's coming up. Partial rent payments. Okay. How much can the rent be raised? So we mentioned this. So the rent is 5% plus the rate of inflation, or 10%, whichever is lower. Here it is. This is it. For rental agreements with a fixed term, i.e. 6 months, 1 year, 2 years, the landlord cannot increase the rent during the rental term unless it is agreed upon in the lease. Rents may increase if the rental agreement is renewed. If it's periodic terms, meaning week to week or month to month, properties are subject to 30 days written notice to any proposed rent increase. And there is other requirements that if it's, there's different details about notice for rent increase. So make sure if this applies to you that you understand all of this. This also talks about retaliatory rent increases, notice of effective dates, example of rent increase. Also, this is really interesting. In California, they're giving a beginning January 1, 2025, landlords with some limited exceptions must give their tenants the option of having a positive rental payment history reported to at least one wide national credit reporting agency. So positive rental payment reporting to consumer reporting agencies. Positive rental payment information is information regarding a tenant's complete and timely rent payment, but does not include any instance in which a tenant did not completely pay. So basically, it's only reporting what was good, which if a tenant wants that, that's good. Let's see, what else? When can a landlord enter the unit? This is about accessing the unit. And sometimes when it's overused, it's called abuse of access. But there's a bunch of different, basically, if it's an emergency, then you're going to go in without notice. Then it gets into subleasing, subletting, assignments, short-term rentals, repairs and habitability. Okay, so I'm just going through this. Responsibility, okay. Repair and deduct. So if there is, honestly, if there is something that the landlord needs to repair and that if the tenant isn't repairing it, or if the landlord isn't repairing it, the tenant's got to take matters into their own hands if they have properly communicated to the landlord that something is wrong. And that's usually in writing. Giving the landlord notice. Yep. Tenant information. Yeah, so here's landlord's obligation to change the locks for victims of abuse or violence. Landlord's sale of the rental unit. Condo conversions, demolition of the dwelling. Influencing the tenant to move. California law protects the tenant from retaliation by the landlord because the tenant has lawfully exercised a tenant right. California law also makes it unlawful for a landlord to attempt to influence a tenant to move out by doing any of the following. Basically, engaging in conduct that constitutes theft or extortion, using threats, force, or menacing conduct, or committing a significant or intention violation of the rules. You can tell that this has all happened in the past, which is why it's all in here. That's kind of sad. Proper notice of moving out. This is all about moving out next. Making sure that you're giving proper notice. At fault versus no fault. We've already mentioned this. Refund of security deposits. And initial inspection. So at the move out, they're encouraging the tenant and the landlord to do basically a pre-inspection of the rental before the tenancy ends to know ahead of time what needs cleaning or repairs. So they call it the initial inspection, and the final inspection is at the move out. And so that's when everything should be done completely empty. So they actually do 2 move outs, which is interesting. Costs of cleaning. Okay, I'm just going to keep going down here. Oh, tenant's death. This is interesting that this is in here. If the tenant dies during the term of the tenancy, the tenant's estate is overseen. If the tenant had a fixed term rental agreement, like 6 months or 1 year, and then dies, the tenant's estate will be responsible for the remainder of the term. The tenant's estate may surrender the tenancy and return possession back to the landlord, but the estates will remain responsible financially unless or until the landlord relets it. So you can tell this is not a abrupt ending. When you've got you are responsible for the term of the lease, which not all places are. Even if you sign a 1-year lease, if the tenant cancels the lease, they are no longer responsible for the remainder of the lease. Talking more about special rules for tenants in the military, inventory checklist again. This is about move out, terminations, and evictions. I'm going to keep going down here. 3-day notice. This is basically demand to pay. And here we go. California has lots and lots of details in all this. Okay, they have a really good glossary too. Really good glossary of terms, credit score, discovery, discrimination, elder abuse, eviction, lockout, tons and tons. There's pages and pages of just definitions. It's pretty cool. Okay. And then they have all these appendix. I don't necessarily need all that. Oh, yes. So this inventory checklist. So the last, there's 4 pages of this inventory checklist. And so it's really nice actually, but you can see there's, if you're looking at YouTube at My Life as a Landlord, you've got the item and then you've got condition upon arrival, which would be done at move-in, and then condition upon initial inspection when the tenant has given notice that they're leaving, and that's the middle column, and then condition upon departure. So this is a high level of engagement. Sometimes the tenants do not engage this much, and just letting you know. But in California, this is actually really good that they do this initial and then final move out inspection. And then they have all the footnotes. Okay, so let's get back to this. Some of the unique things in California we've talked about already, about not being able to use criminal history to help qualify or not qualify a tenant. One thing I didn't mention was shared utility meters. Dwelling in older buildings may not have separate water meters or sub-meters. So if you're paying for utilities, or if your tenants are paying for utilities separately, then you need to make sure that you're showing how your tenants are getting billed and how it's being calculated for that bill. And then I mentioned Megan's Law and lead-based paint. Oh, this is something interesting. The National Housing Law Project has created an early lease termination toolkit for ending leases due to domestic violence, sexual assault, human trafficking, stalking, elder abuse, dependent adult abuse, to end leases early in California. And that toolkit I've actually added as a hyperlink in the description for this podcast episode. But if you want to know more about it, National Housing Law Project is at www.nhlp.org. Early lease termination toolkit. Very cool. Basically trying to figure out, make sure that everybody's doing the right thing. And that even if it's traumatic, you know that it's there. That's pretty interesting. There's also been a couple things that I was really interested in when we're talking about security deposit deductions, about calculating the useful life of things like your drapes or carpets, repainting walls on a sliding scale based on the time in the unit. These are all really interesting ways to deduct normal wear and tear, or maybe not normal wear and tear on your unit. And very reasonable, right? Like if anybody was to fight you on this or to dispute this, then it would make sense that, you know, if you show this calculation, it's interesting. Tenants filing bankruptcy. In fact, they put right in the act here, some tenants think that filing a bankruptcy petition will prevent them from being evicted, and this is not always true. Even if it delays an eviction, filing for bankruptcy without having a legitimate need for other than economic relief is generally a poor idea. This is straight out of the act. Filing for bankruptcy is a serious decision with many long-term consequences beyond the filing eviction action. A tenant who is thinking about filing bankruptcy because of the threat of eviction or for any reason should consult a bankruptcy attorney and carefully weigh their advice. While it is possible for a person to file bankruptcy without the use of an attorney's service, it is ill-advised at best. Retaliatory actions, we talked about this, and it looks like from what I could find, the time frame is 6 months. So within 6 months, if a landlord is doing anything retaliatory in nature, increasing the rent or evicting or reducing services, things like that. Yeah. Let's talk a little bit about abandonment of items in California. Now, I just Googled abandoned items tenancy California, and up had a whole bunch of websites that came up. One of them is here. This is the Legal Beagle. I know that this is a sort of a national, they'll have abandoned property in all the states. So I just picked California just to see if this was it. This one, make sure it's abandoned. That's interesting, that if you're thinking that you have a unit that's abandoned, make sure that it's abandoned. Make sure that they're not actually on vacation or away on business or something like that. But if the tenancy is terminated, the tenant has been evicted, and you can no longer get a hold of the tenant, or you just want to make sure that it's actually been abandoned, that it's actually been, you know, the unit has been turned back over, right? provide proper notice of the abandoned items. So you want to make sure that you are mailing, calling, any way you possibly can to let them know that they have abandoned property, and to let them know that they could be charged for reasonable storage expenses. Because, I mean, let's face it, if you've got an abandoned unit, as a landlord, you're going to want to put their items either in the dumpster or in storage. Probably in storage is smarter. And then let the tenant know, or the former tenant know, that you're storing these items. And then while you're trying to recover the unit, trying to get a new tenant screened in that unit while you're dealing with this storage of these other items. And then returning of abandoned property. By California law, you can't, you have to look for at least 15 days or 18 days when the notice is delivered by mail or email. You have to actually try to get a hold of them. And if they haven't, and the items are in storage, then at some point after their notification period, whichever one it is, 15 days or 18 days, you can sell, trash, or tow. And when in abandoned items, it's all about what's the dollar amount and the time. So the time is 15 or 18 days, and the dollar amount is $700. So landlords may keep the property to use as they please, as if it's valued at less than $700. If it must be sold according to California Civil Code if the property has been valued at over $700. So abandoned vehicles are sort of their own thing. And you'll find that very likely in other places as well. If you've got abandoned vehicles on your property, regardless of the location, it's usually got its own set of rules, and California law is no different. It's got its own set of rules. So abandoned private property, and then you've got abandoned cars. So you want to make sure that you are adhering to the right one. And I've got those hyperlinks to both of those in the description of this podcast. So let's talk about where you can get help in California. I see lots of California landlords on Facebook all over the place asking questions about what about this and what about that. A couple places you can go for legal aid help. Legal aid help in California is www.lawhelpca.org. If you need help with legal resources, this one says low income legal resources, but I'm sure they could guide you. This is the California State Bar, and the website is calbar.ca.gov, and that will lead you to getting some help. If you are a member of the military and you need military housing help, this is something not just for California, which I found interesting, but there is a huge military presence in California. You go to jag.navy.mil/legal_services, jag.navy.mil/legal_services, and a couple more. California Apartments Association. If you are a landlord looking for a membership type organization to help educate you as a landlord, California Apartment Association is likely going to help you. And you go to caanet.org. And one last one, Self-Help Courts for Landlord and Tenants Judicial Branch of California. The website there is selfhelpcourts.ca.gov/eviction-landlord. Selfhelpcourts.ca.gov. Okay, as we come to the end of this California location-specific episode, just a reminder that each of my location-specific podcasts are set up in the same way, answering the same 4 questions, going over the basics of that location's landlord housing governing document, talking about the differences and the uniqueness of that document, and getting some guidance about abandoned items left behind by a tenant and where you can go for help in your local real estate or province. This is the same format for every location-specific episode. So if you're interested in another geographic area, you already know what I'm going to talk about, just in a different location. But a reminder one more time, this episode is not all-inclusive. You must research further in your specific area, including your county, city, regional district, parish, city, or any other governing body that involves your rental. But at least today's episode will get you started. If you're listening to this podcast, chances are that you are either new or wanting to be, or maybe you already are an existing real estate owner in California. Things you can do to help yourself are read the California Tenant Protection Act and the resources that I'm providing to you, and get familiar with other landlords in your local area. You can do that on social media, go to Facebook groups. There are national landlord help groups, but there are also specific location help groups. I'm sure there's one for California, and maybe one for your city, depending on where you are. But you can also go to in-person meetings such as meetups. So just jump on social media and ask and see if you can find an in-person group meeting in your local area. Lots of local folks asking questions just like you are. If you learned something from today's show, could you pretty please give me a review on whatever platform you listen to this podcast on, including Apple Podcasts, Spotify, YouTube, or maybe you listen to this at mylifeasalandlord.com. It really doesn't matter where you listen to it, but your input really does help. I hope you enjoyed today's show all about California. Today, I'm recording this episode on board the cruise ship, the Carnival Splendor, and we are located off the coast of New Zealand. Real estate takes you places. Where do you want real estate to take you? Join me in the next episode, live right now in the library, episode 128, all about Texas.